But I can
and
tell
they'll
you,
have to accept the
he's not a
transfer.
good candidate for probation.
He's not?
No, he's not.
No. I'm not asking to withdraw as his lawyer. I'm asking for the court to be recused.
All right. Well, there's another judge. We'll have to hear that.
That's correct, Judge. So I'm a few more days to properly
Oh, there's
prepare.
nothing for me to do on the case once you file that 2025.
We're
Last statement was not, that was the part of the report attachments where he had allegedly had contacted her through after the election.
All right.
So as far as that, Judge, we're pleading no contest. My client has no prior offenses. The
Well,
state can.
no. I'm
No,
trying
but
to see if
I'm
there's.
trying to get there. I'm trying to get there as to our application for, we are applying for deferred adjudication. And so because of that, I would not want him to make any stipulation. So that's why I asked him to plead no contest. Because if the court should grant him deferred, then
Well, here's the thing. I don't have that in the stipulations to prove the 2025 CR 004086. Now, if somebody wants to amend this and attach jail calls, they can attach it, but I don't have enough proof in here for these other dates. The only date that I have in the stipulated evidence is I have a date from January 5th for violation of protective order. But the other dates I don't have in here. Sure. So if y'all want to step back, you can, but in cause number 2025 CR 03533, the court is finding that there is sufficient evidence to find you guilty. The court will defer finding of guilt. It takes about 8 weeks to 12 weeks for a PSI. If you would like to have him come back without a PSI, but just have time to call witnesses, you're more than welcome to do so.
so I've conferred with my client, and I've also contacted family members, and my client wishes to waive PSI, and just have the court, and that was why we took a little bit of a recess, Judge, before we got on the bench, is just to confirm the criminal history. And so at this time, we're asking the court to waive PSI, and we proceed with sentencing today. Your Honor, my client, he's 27 years old. He is not native to Texas. He's from Indianapolis, Indiana. I'm sorry, Chicago, Illinois. I apologize, but he, as mentioned before, he's 27 years old. The victim and him are obviously very familiar. They've been together since they were children. So I think since they were like 16 years old. Is that right? 16? 15. Since they were 15.
Does he want to testify?
No, Judge. Let me just finish. I'm so sorry.
All right. So you can't get information from him, then turn back to the court to give whatever information he's given you if he's not going to testify.
Okay. I'll just
All
proceed.
right.
I'm sorry, Judge.
No problem.
And they do have 3 children together. And obviously they've had a myriad of things happen, I guess, in their lives, and they have both matured and progressed. And my client wishes to accept responsibility. He understands that the only way he's going to see his children, because that was another thing that we talked about, was that there will be a no contact order. That is something that obviously he's vehemently opposed because he does have 3 children. And so I did advise him that this would be part of the plea agreement, and if he wants to hire a lawyer and get some custody issues and orders in place so that they can go around that order, in order for him to be able to see his children, because obviously the state is not asking for a no contact order with the children. It would only be with the mother, the natural mother, which is the victim here. I have spoken to his father. I am not sure if yesterday he was on the Zoom and standby, and I mentioned him that he would at the same time today. And I don't know if he's in the waiting room or not, but notwithstanding, my client does want to go forward. His father obviously speaks very highly of him. Unfortunately, he did get arrested in February 27th, which is when he got booked for the last time. So he's been obviously in custody for almost going 3 months now. He's got health issues at the jail, Your Honor. He's got psoriasis. He lost about 110 pounds in those 3 months So he's had some kind of health limitations. And so a lot of that is going into why we have this agreement. Obviously, I've explained to him multiple times, that we could ask for a jury trial from the court. But given the history with these people, that obviously he wants to accept responsibility, and he's wanting to do that today, Judge. And with respects to just putting it on the record, I do want to state that we took a little bit of time going over the criminal history. There was a jury trial that happened in December of 2019 in Indianapolis, Indiana. So that's why I'm sorry, I was confused about the city. That there was an actual jury trial, and he was adjudicated not guilty with the same victim. There was also, I want the court to take judicial notice of clause number 2025 CI 04103. There was an application for protective order that was made by the victim February 25th, 2025, and it was non-suited in April 17th of 2025. My understanding, and prosecutor wouldn't really talk to me too much with respects to the protective order, Ms. Colon, but she did confirm that it was non-suited due to her leaving the state. So the victim,
Due to what?
the witness leaving the state.
Okay.
So as we stand here today, we have obviously my client hasn't had any contact with her since then. And then, but she has been in contact with the state, which obviously, we know that is for a fact, but obviously he's very concerned for his children. He wants to know their whereabouts. And he did meet with a recruiter, and I did speak to him on the phone. He would not come in for the PSI. His name is, Eggerson is his last name, Sergeant Eggerson, and I did call the number. Let me see, on Potranco Road. It's 11223 Potranco Road, and unfortunately, Mr. Ross was in the process of being recruited to the Army, and so obviously he understands that accepting responsibility for this charge, and should the court grant him deferred, he will not be able to possess a weapon while he's on deferred. But the hope, I guess, is that once he's completed the deferred, is that he'll be able to enlist at that time. So our agreement right now is 4 years. Now the court can give him probation, the court can sentence him, or the court can give him deferred, which I believe he's legally entitled to because he has no convictions.
What do you mean he's entitled to deferred adjudication?
Okay.
Legally?
Well, I would ask the court to take that into consideration, that he has no legal convictions under any other ordinary circumstances. He has no prior offenses.
Okay, but
convictions. And so,
but if you're
he's
saying
a first-time offender,
all right, but if you're saying he's legally entitled to deferred adjudication on this case,
I have no statute.
all right.
If the court, I have no statute, but I'm just saying as a matter of principle, as a matter of, mercy on my client, the court, I should hope, at least, because again, he's also been in contact with being recruited, that he would be granted deferred adjudication. And, he wants to move on with his life. He wants to start probation. He understands that should the court grant him probation, he'll have to be here for 45 days, right? You understand? You understand it? And that if he wants his probation to be transferred to Indiana, it'll have to be transferred within that time frame.
All right. So what I can
And
tell
they'll
you,
have to accept the
he's not a
transfer.
good candidate for probation.
He's not?
No, he's not. And let me just tell you why. Based upon everything that I've seen, there was a protective order in place, and you were calling the complainant from the Bexar County Jail. I mean, does he not understand what no contact means? No contact means no contact. And then we have this charge where you're choking her. So he's not a good candidate for probation. I'm not giving him probation.
Well,
In each cause number, I'm finding him guilty. I'm going to sentence him to 4 years in the prison, give him credit for any time served. There's a $1,500 fine, time and money to run concurrent. The cases are to run concurrently. There's to be no contact with the complainant and no contact with minors. And cause number and cause number 2025 CR 003533. There's an affirmative finding of family violence. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal in each cause number? With your attorney, did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because one of these cases carries an affirmative finding of family violence, and also because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney.
Sorry, may I speak to my bad, please?
Your attorney said that she did not want you to speak. The court has passed sentence.
I didn't know that I couldn't. I thought I had the whole time to testify. I thought she would.
I asked you if
All
you
right,
wanted
so,
a jury trial.
They're going to take you back. If
Can I
there's something
please-
else you all want to discuss, if you want to file a motion, you can file a motion and the court will hear that
Can I
motion.
speak on my behalf? Can I please speak on my
I don't know what
behalf?
you-
I just want to testify. I didn't.
Patrick Washington. All right. The last time you were here, and I'd like for people to feel as though, and not actually just feel as though, but to have had a chance to speak to the court, and it appeared that you wanted to speak to me.
Yes, I did.
All right. And what did you want to speak to me about?
Yeah, I have a second to breathe. I kind of got worked up a little bit.
I'm sorry, what?
Can I have a second to breathe? I kind of
Sure.
worked up a little bit. Just pertaining the case, and I know when you went over it, you seen that the protective order was violated multiple times. It's not. I know it. If you read police reports or a person's victim's testimony of what happened, sometimes it could. It's up to the court, your discretion to see if, try to make sense of it, I guess. But when it comes to probably protective order, we have children together, and to be honest, like I never been in any trouble before in my life pertaining like legal system and having to no contact, like the contact order with my children. And I was a sole provider for my children. Like she was a stay-at-home mother. And when I went back home, like the no contact order, I went back home, but I was the only person on the lease, and I didn't have anywhere else to go. And honestly, from what we talked about pertaining me and her, we were fine on good terms, etc. So to be honest, I didn't think it was gonna be any more.
But see, here's the thing about it is that there's an offense against you for choking, right? And when you think about it, choking a person, that means you're face to face with them. They can't breathe, and you're still choking them. Now, you have that, so you have to know that there's a no contact order in place. And when you're saying, oh, well, I leased the apartment or the house or whatever, that's why I was going back there. Okay, I understand that. But when you were placed in custody at the jail, both parties agreed, your attorney agreed and the state agreed that you were actually contacting her from the jail. And so the thing about it is, you already have this violent offense for choking someone. And then on top of that, you are continuing to contact them from the jail. You had to know you couldn't contact people from the jail. And that just shows the court that you can't follow rules. And she has, according to the testimony that is taken, she left town and is no longer in Texas or wherever she may be. Then, it is what it is. She left town. Maybe she left because maybe she's thinking, I leave town, he doesn't know where I am, then he can stop contacting me. But that's where we are.
Yes.
Sure.
Okay.
To be, I don't know how much I say before.
Well, you're not under oath.
Oh, okay. Well, I could speak freely. Yes. Um, Your Honor, he came back and forth to see me unannounced. Came to the house unannounced. She when she was in a woman's home in Fredericksburg, she was they kicked her out of the woman's home, and the police had to come or whatever to escort her away. She came to the house on February 4th or 5th, unannounced, midnight, because I wasn't speaking to her because we were talking during the protective order. We have children. I was sending money for my children, or she would bring the children so we could see them. We would eat together.
Right, so here's my question. Were you sending money to the children from the jail? That's a no.
No.
But you were still calling her from the jail, and that had nothing to do with anything. So here's the thing. I wanted to hear you out because I know I didn't get a chance to fully explain to you why I didn't grant you probation. But the reason why I didn't grant you probation is because you have a crime where you choke her. And then after you choke her, you continue to contact her. What I'm letting you know is I understand, okay, you're on the lease. You go to the apartment or to the home because you're on the lease and you're trying to make sure that the children have food or have money. That's fine. But then you proceed to call her on numerous times from the Bexar County Jail. That's a no. And for the court, part of the reason why I didn't grant you probation is because based upon your actions, you're telling me you can't follow conditions of probation. So that is why.
I actually, Your Honor, if possible, because before this happened, I was enlisted actively in the military. I was enrolled into medical school for LMRT classes to become a radiologist. And my classes started in March 2025. I've been in and out of grew up in the jail, etc., house arrest, etc. since then. I understand exactly where you coming from and how it could seem to the court, or even like the charge, or etc. I've been sitting in jail and dealing with different health reasons, low potassium and low liver enzymes since the date of my arrest, December 5th to March 18th. I was admitted to the hospital. I had lost 110 pounds because I wouldn't eat because I had psoriasis, which is like my skin breaks out from certain foods, meat, dairy, etc., sugars, have you. I grew up in a family where my immediate household was my father, my brother, and myself. Out of us three, both of them are felons, and neither one of them graduated high school. I'm the only one who graduated high school. I'm the only one who wasn't a felon. So applying for the probation and adjudication was trying to save me from becoming a felon. I took pride in not having any criminal history. If you could so grant me, I don't have obviously lawyer here, but I was thinking
You can always come back with your attorney. I tell you what, I'll have you come back with your attorney. If you want to come back with an attorney, you can.
No, I'm just speaking to you. I mean, it's up to you. I mean, I just don't want to be a strain on my family, and being that I know that I would abide to any probation adjudication, especially the first. I can try to save my record and save me to be able to go on and have a career in any field or even enlist in the Army still. I would say if you could maybe think or ponder on doubling the sentence to 8 years probation deferred and double the fines. And if you could possibly consider a no harmful contact, because Carissa has my children and Carissa has my children. She has my car. she has a bunch of my possessions. No, from our family, both of our families know each other. I knew Carissa since I was 14 years old. Both of our families know each other. Carissa doesn't, her family has, she's left her family.
Let me just tell you this. What I would suggest to you is speak to your attorney. The reason why I had you brought back is because I felt that there is something you wanted to say. And I know I didn't get a chance to explain to you why I made the ruling I made. And I will tell you, we're always taught as judges never to explain our rulings, just make the ruling and move on. But I don't like to do that because I don't want people to think that I haven't heard their story or I'm not paying attention to them or that I'm not looking at them as individuals. So I noticed as you were being taken away, you were raising your hand. And that made me realize that I really didn't get a chance to explain to you why I ruled the way I ruled. Now, if you're asking or wanting me to perhaps do some type of different sentence, and for me to consider that, then your attorney will need to file a specific motion for that. The coordinator will let your attorney know, and we'll go from there. Okay?
May I say something?
Sure.
From I was told yesterday that my lawyer or attorney made motions for reconsideration and a bunch of other motions.
I haven't received those.
That's what I was told from my family when I called. Before I went up here, it's all off the record.
Yeah, we're off the record.
The
court reporter is not taking anything down.
I didn't understand what I signed with the silent.
All right, so here's the thing. You need to talk to your attorney about that. So everything else that you're about to say now, you need to talk to your attorney. Your attorney can file whatever motion she chooses to file, okay?
No, I was getting to what
No, you're getting to places that you should not get to.
I was stuck there, but I'm saying that before we came up here, I was told several times that I could be able to.
No. Here's the thing. You are now trying to, attempting to wade into legal matters. And I think you should have your attorney here to discuss that. All right? So, Ms. Ferguson.
Yes.
Has a motion been filed by his attorney?
I need to double check that, Judge. I don't, do you have his case number, Judge?
No.
They're right.
Okay. All right. And if they have filed, if she has filed something, we'll put it on a docket for it to be heard, and Ms. Ferguson will set it. So just have a seat, and Ms. Ferguson, if she finds something, we'll set it. All right? Okay. So when are we available to hear whatever motion she has filed?
I can do it the first week of June. I need to contact Anita to make sure she's available.
All right. So as soon as your attorney is available before 30 days, we'll hear her. Okay? And if you have some type of food intolerance, you need to let the jail know. If you let the jail know, they will prepare you a specific meal.
I literally, this is all in the notes. This is all the thing I told, when I had Zoom court for the protective order hearing, I would go to Zoom court in jail, and I told,
Deputy Mejia, will you please let the jail know that he has food intolerance to dairy?
No, it's not just dairy, it's meats, processed foods.
All right, he can't eat any processed food. Will you let them know that he needs to eat green? Yes.
Your Honor, he needs to submit a sick call so they can verify he does eat, that he's allergic and can't tolerate that.
Your Honor, I can tell you exactly what happened. I was in jail for 34 days.
So here's the thing. The only question that I need to know is, did you submit what wrong he did?
It's a lot of medical blood work. I took a lot of
submit it?
I've been in and out of, yes. I went to the
No, my
hospital.
question is, did you submit the form to the
Yes.
proper people?
Yes, several times.
All right, so Deputy Laura, if you can make sure that the jail has the information on him, and I will send an email.
And I didn't eat until I went to the hospital after 30.
I will send them an email about your intolerance. Is there anything else?
That's it.
All right, so I'm going to send an email right now about your food intolerance. So what specifically can you not eat?
I was wanting to just get some type of fruit, and they didn't give me any fruit. They said because it's hooch and all this.
Okay,
other
this is
stuff.
what I want I want you to listen to me and internalize what I'm saying. As my grandmother would always say, it's not about who shot John right now. So somebody did something or they didn't do something. I'm not at that point right now. Where I am is you're telling me you have a problem. I'm trying to solve it. So I don't need to know the backstory. I'm just trying to figure out what are you not allowed to eat? What can you eat? And I will send an email to the sheriff letting him know that you are not allowed to eat dairy. So other than dairy, what else can you not eat?
Meats, processed food. I just really fruits and vegetables. But,
All right, so you're not allowed to eat meats or processed food. And what are the results if you eat meats or processed food?
I have skin breakouts in my face and hair areas, etc., and it gets like red irritants with psoriasis.
All right.
I didn't mean to agitate.
No, I mean, I just want you to tell me what can you not eat? The fact that somebody is still serving you specific things, I'm trying to solve that problem, but I need to know what you can't eat. So you're telling me no dairy, no meat or processed foods, correct?
Yeah.
All right. All right, thank you.
Thank you.
Mr. Ross, this one. Your Honor, family violence.
All right, could I have his file, please?
Who is that? Jalen Ross.
And I see it's raining.
Oh yeah, I got poured from I got wet from head to toe. But I was having like a lot of problems. Like last night, my power kept going out. It went out like 5 times, and then like this morning, I couldn't hear you. So I apologize, but
No problem.
I did confer with the state, and we.
The motions that she just filed this morning, we haven't had proper time to review them, and we'll give this at least 3 days before those motions are heard.
Oh, we can go for it. It's a motion to
No,
reconsider.
I wanted to start to talk about it in chambers if that's possible.
All right, so here's the thing. Once I have motions to reconsider, I always tell people,
Excuse me, it went mute and I can't hear or see anybody.
yes, I know it's mute.
Oh,
Let me unmute. All right, so I'm not going to reconsider his sentence unless there's some evidence where he should have a motion for new trial.
All right,
Not
that's
gonna-
correct, Judge. So I filed a motion to withdraw the plea, and I've also filed a verified motion to recuse.
All right, I don't have the motion to withdraw before me.
I have copies. So
And
that's
you
why
want to
I'm-
withdraw.
No, I'm not asking to withdraw as his lawyer. I'm asking for the court to be recused.
All right, well, what I can tell you is I'm not reconsidering any sentencing. And if you want a motion to recuse, another judge will have to hear that.
That's correct, Judge. So I'm asking that it be, and I know the state's asking for a few more days to properly.
Oh, there's
prepare.
nothing for me to do on the case once you file that. All right, thank you.
All right, thank you, Judge.
You're welcome.
Her strategy worked. Another court granted the recusal on July 16th, 2025. So Judge Boyd was removed from the case. The defendant's attorney, Anita Perez Garza, kept fighting and asked the new judge to take another look. This new judge is Lisa Jarrett. She's a longtime judge of San Antonio with a vast experience in juvenile court. And this is what happened next. On August 1st, 2025, Judge Jarrett granted the reconsideration. She resentenced the defendant to 8 years deferred adjudication. This is less than probation, strict rules and supervision like probation, but without a conviction on the defendant's record. The defendant was released the next day. A huge difference in sentencing.